Chapter 8. Modification and Termination of Trusts. Key exam issues. Exam questions concerning the modification and termination of a trust may present issues about the possible existence of an express or implied power of modification or revocation retained by the settlor or granted to the trustee, or may require you to consider the proper scope or manner of exercise of such a power. They may focus on creditors' rights issues, or even involve the possibility of termination of the trust by operation of law. But the most important exam material in this chapter has to do with the ability of courts and beneficiaries to modify or terminate trusts. 1. Before finding that beneficiaries may modify or terminate a trust, be sure to consider a. Whether the consent of all possible beneficiaries, present and future including contingent beneficiaries, has been or can be obtained, and watch for issues about their legal competency or obstacles presented by possible unborn beneficiaries. And b. Whether the Claflin majority view or the English or other minority view is applicable. If the Claflin doctrine applies, determine whether a material purpose will be defeated by the modification or termination. If so, there can be no modification or termination. Of course, if the settlor is living, she could waive the material purpose. 2. The judicial power to modify or authorize deviation requires consideration of whether the proposed change involves taking from one beneficiary and giving to another, sometimes less precisely discussed in terms of distinguishing administrative from distributive provisions. If not, deviation may be available if a. There are changed circumstances that were not anticipated by the settlor, and b. These changed circumstances threaten the accomplishment of a trust purpose, which requires more than merely convincing a court that the contemplated modification would improve administration of the trust or would be in the best interests of the beneficiaries. A. Power of settlor to modify or revoke. 1. When does settlor have power to revoke or modify? A. Majority view only if reserved 1927. Under traditional common law, the settlor of an inter vivos trust has no implied power of revocation or modification. For the settlor to have such a power, it must be included in the terms of the trust as an express provision or found by construing language contained in the instrument. Rest. 2D 330. 1. Generally must be reserved at time of conveyance 9 or 28. Gifts, unless qualified, are irrevocable. The donor cannot thereafter take back the property. Similarly, once a living trust is established, it is a completed transfer of all the legal and equitable interests, thereby created, including interests in unborn and unascertained beneficiaries. When the transfer is gratuitous, it is a gee and irrevocable unless otherwise provided. Hence, the general rule is that the settlor must reserve the right to revoke or modify at the time of transfer, or no such power exists. 2. Exception Totten Trusts 929. Despite this general rule of irreversibility, most courts hold that bank account trusts, where A's funds are deposited in the name of A in trust for B, or the like, are presumed to be revocable. See Supper 418-431. 3. Distinguish settlor as sole beneficiary 930. If the settlor is the sole beneficiary of the trust, she has the same rights as any other sole beneficiary would have to modify or terminate the trust, in fact, sometimes greater. See Infra 977. 4. Distinguish third restatement position 931. If the instrument is silent on the point, it is a matter of interpretation whether the settlor has power to revoke and amend rest. 3D 632, with a presumption that she has if she retained any expressed beneficial interest or power of appointment under the instrument C rest. 3D 63 CMTS, C, CL. B. Contrary statutory view 932. Many statutes are now contra. For example, the California Probate Code has long provided that a gratuitous trust is revocable unless it is expressly made irrevocable by the trust instrument. Cal. Prob. Code 15E400. This view is now widely being codified prospectively by enactment of the UTC 602A. C. Distinguish rescission and reformation 933. Despite the absence of a reserved power of revocation or modification, a trust may be rescinded or reformed, including to supply a mistakenly omitted power to revoke on the same grounds as a like transfer free of trust. See Generally Remedies Summary. This requires proof of some recognized ground for relief, such as fraud, abuse of confidential relationship, undue influence, or mistake. Rest. 2D 333, a quite flexible enhancement of the judicial power to reform for mistake, is provided in the UTC 415, requiring clear and convincing evidence. And see Rest. 3D 62. But see Flannery v. McNamara, 738 NE 2D 739 Mass. 2000, rejecting the counterpart Rest. 3D of Propetti 12-1 with respect to testamentary trusts and reviving the traditional distinction between wills and inter vivos trusts. 1. Note. In the case of the typical donative trust, an appropriate form of unilateral mistake can suffice as a ground for reformation or rescission. However, it is generally said that mere misunderstanding of the legal effects or unanticipated consequences is not a sufficient ground. Ellis. Tellier, annotation, cancellation of irrevocable inter vivos trust on ground of mistake or misunderstanding. 59 ALR 2D 1 and 2 29 1958. Yet, cases are sometimes more lenient, as illustrated by those granting such relief for mistake as to tax consequences. Scott on Trusts 333-4. Compare the Reformation Rule of UTC 416 and Rest. 3D of Property 12-2. 2. Nature and terms of power to revoke or modify. A. Scope of retained power. 1. Power to revoke 934. Where the settlor has reserved a power to revoke the trust, she also can modify it, on the theory that the greater power includes the lesser. Moreover, it would be a pointless formality to require the settlor to revoke the trust and create a new one with the desired modifications. Heifetz v. Bank of America National Trust and Savings Association, 147 Cal. App. 2D 776 1957. A. Limitation 935. Nevertheless, it may be that an amendment to the trust that would render the trusteeship more burdensome either requires the trustee's assent or allows the trustee to resign effective when a proper successor is in place without prior court authorization. 2. Power to modify 936. Courts have also generally held that reservation of an unrestricted power to modify or amend a trust includes the power to revoke it. Stoller v. Sevener, 84 NE 2D 447 Mass. 1949. Rest. 3D 63 CMT. G. Exam tip. If you encounter an exam question that asks whether the settlor can modify, amend, or revoke a trust, look at the terms of the trust. The settlor cannot modify or revoke an irrevocable trust. However, if the settlor has reserved a power to revoke, i.e., the trust is revocable, she can revoke or modify the trust. If she has reserved an unrestricted power to modify, she can generally also revoke the trust. Also keep in mind the widespread statutory rules supra. 932. The modernized Third Restatement of Trusts view supra. 931. And perhaps the Third Restatement of Trusts and Property views on Reformation supra. 933. B. Exercise of retained power. 937. A power to revoke or modify can be exercised only in accordance with its terms and by intentional act. 1. Exercise by will. 938. Most courts have held that a will is ineffective to modify or revoke an inter vivos trust. John P. Ludington, annotation. Exercise by will of trusters reserved power to revoke or modify inter vivos trust. 81 ALR 3D 959 1977. A. Exception express authorization 939. Of course, if the trust instrument authorizes exercise of the power by will, the result would be different. Generally, whatever method of revocation is specified in the trust instrument will be given effect. B. Exception Totten Trusts 940. The result is also contra for Totten trusts. They can be revoked by the settler's will if the intention is manifested expressly or by clear implication. See Supra 418-431. C. Contrary View 941. There is modest authority presuming that a power to modify or revoke can be exercised by will, unless its terms indicate the contrary. Rest. 3D 63 CMT. H less equivocal than rest. 2D 330. And CUTC 602 C2. 2. Exercise by third party 942. It has been said that a power to revoke or modify retained by the settler cannot be assigned to another person. It is personal to the settler. This is dubious in the case of a power to revoke or an unlimited power to modify. Compare creditors' rights below. A. Conservator 943. The power can be exercised by a conservator or whatever term is locally applied, e.g., guardian, committee if the settler becomes incompetent, to the extent necessary for support, etc. If other funds are insufficient, and probably absent contrary provision, and with court approval, for purposes of amending the settler's estate plan. See Rest. 3D 115 and CMT. F. Also agents so authorized under a durable power of attorney. UTC 602F. B. Trustee, beneficiary, or third party 944. In creating or, unless restricted, in amending a trust, the settler can grant to others, including a trustee or beneficiary, the power to modify the trust, the power to terminate it, and thereby, if a beneficiary, receive part of the trust estate, or the power to appoint interests under the trust. C. Attorney in Fact 945. The law is generally undeveloped with respect to the exercise of the settler's powers to modify or revoke by the holder of the settler's durable power of attorney. A few statutes expressly deal with the matter. See, e.g., Cal. Prob. Code 15E 401C. No exercise by attorney in fact unless expressly permitted by the trust instrument. Rest. 3D 115. UTC 602E. Exercise by attorney in fact permitted, if expressly authorized by the terms of either the trust or the power. 3. Rights of settlers' creditors, where settler has power of revocation 946. If the settler was solvent when she created the trust, so that the transfer was not a fraudulent conveyance, under the traditional majority, but declining view, creditors of the settler cannot reach the trust merely because she reserved a power of revocation. Under this view, the conveyance is complete, and the settler cannot be compelled to undo it and undermine the interests of other beneficiaries. Rest. 2D 330 CMT. O. A. Settlers' beneficial interests, reachable 947. Creditors can, however, reach the interests retained by the settler, e.g., right to income for life, even under discretionary and spendthrift trusts. Rest. 2D 156. This makes the above traditional view somewhat absurd. B. Note growing authorities contra 948. There are statutes or decisions in a growing number of states, probably now the predominant view, under which creditors of a settler can reach the trust estate if the settler holds a power of revocation. NY. EST. Powers and Trusts Law 10.10.6. Sonnabend v. Giddens, 235 AD, 483 1932. And C. State Street Bank and Trust Co. v. Reiser, Supra, 123, even after death of settler. Rest. 3D 252 CMT. E. UTC 505 Al. C. Bankruptcy 949. If the settler declares or is forced into bankruptcy, the trustee in bankruptcy obtains and can exercise powers retained by the bankrupt settler, thus permitting creditors to reach assets held in a revocable trust. B. Power granted to trustee, beneficiary, or third party to modify or terminate. 1. Only as conferred by trust terms 950. The trustee has only such power to modify or terminate the trust as is conferred upon him by the trust instrument, expressly or impliedly, or, in the case of a valid unwritten trust, by its provable terms. A power to modify or terminate may also be conferred b. Trust provision on a beneficiary or third party. Rest. 3D 64. 2. Power of invasion 951. A trustee's power to distribute, e.g., power to invade principal may, so long as properly exercised, cause a trust to terminate. 3. Judicial supervision 952. Where a trustee exercises a discretionary power to modify, terminate, or to distribute trust funds, his exercise or failure to exercise is subject to review by an appropriate court. Judicial review is thus available for abuse of discretion. Corkery v. Dorsey, 111 NE, 795 Mass. 1916. This would also be true if the power granted to a beneficiary or third party is intended to be held in a fiduciary capacity, the basis upon which a court may intervene and substitute its judgment for that of the trustee or other fiduciary depends on the terms of the discretion. Ordinarily, the trustee's exercise must be reasonable in light of the standards provided or the purposes of the trust. But if the authority of the trustee is couched in terms such as absolute or sole and uncontrolled discretion, although such language is not taken literally, the trustee is apparently required only to act in good faith and for purposes contemplated by the settlor. Rest. 3D 87. C. Power of beneficiaries to modify or terminate. 1. When may all beneficiaries join to modify or terminate? A. English and Minority View 953. Absent a special grant of power to one or more beneficiaries, see supra. 950. In England and a few American jurisdictions, it has been held that, if all the beneficiaries of a trust are legally competent sui juris and all consent, they can compel termination or modification of the trust, even if the settlor's purposes would thereby be defeated. B. Claflin Doctrine Majority View 954. The prevalent American view, Claflin Doctrine, is somewhat more limiting than the English view. Claflin v. Claflin, 20 NE, 454 Mass. 1889. As generally stated, it provides that the beneficiaries can compel termination or modification of a trust if and only if I. All beneficiaries, all of whom must be legally competent, but see rest. 3D 65 CMT. B. Join in requesting the trustee or petitioning the court to modify or terminate rest. 2D 3E 371. And Roman 2. The proposed modification or the termination will not defeat a material purpose of the settlor in creating the trust rest. 2D 3E 372. But see rest. 3D 652. 1. Note. A modern view, based on statute or limited case law, is less restrictive in several crucial respects. See Infra 956 et seq. C. Diverse Minority Views 955. A few cases adopt or appear to have adopted views unlike either the English or the majority view, i.e., more restrictive than the English and different from the Claflin Doctrine adopted by most states, see above. 2. Consent of all beneficiaries 956. Whatever view a jurisdiction may hold, consent of all beneficiaries is required. It is therefore essential to understand the meaning of this requirement. A. All possible beneficiaries 957. Consent of all beneficiaries means not only all existing, but also all potential beneficiaries born or unborn, ascertained or unascertained of all interests, present or future, and no matter how uncertain or contingent. 1. Children 958. A deceased settlor's children as, e.g., a class or remainder beneficiaries are all ascertainable because the settlor cannot have any more children after death. But if the settlor is still alive, as in an inter vivos trust, or if the children are those of another who is still living. This class of beneficiaries cannot, at least under the common law's conclusive presumption of lifelong fertility, be ascertained or complete because of the possibility of additional members. 2. Issue or descendants 959. A remainder to a class designated as the issue or its equivalent of a person, whether living or deceased unless leaving no issue, creates an indefinite class of potential beneficiaries. Thus, in such a case, it is not possible to obtain the consent of all beneficiaries. Some may be minors, and necessarily some may not yet be born. Henry Lewis's Estate, 79a, 921 Pa, 1911. A. Note. The above represents the traditional view and literal meaning of the generally stated rule, and the holding of a modest number of reported cases. But see the possibility of vicarious consent, infra 964. 3. Heirs 960. Under the term's usual meaning, the heirs of a deceased person are all ascertainable and are or were at the time of ascertainment alive. But this rule is not absolute. A. Deferred class of heirs 961. If the trust expressly or implicitly refers to a deferred, artificial class of heirs, even of a person who is already dead, such a class of remainder beneficiaries may not be ascertained or confined to living persons. Example: testator devised, to trustee in trust for son for life. Remainder to go to those who would then be my heirs as ascertained at son's death. B. Heirs of a living person 962. The class membership is also unascertainable and open to afterborn persons if the heirs are those of a living person. This rule can be altered by the now rare doctrine of worthier title in an inter vivos trust. A purported remainder in the senior's heirs is presumed to mean a reversion in the settlor herself, or the virtually extinct rule in Shelley's case. A purported remainder in the heirs of the person holding prior freehold estate may irrebuttably mean a remainder in the freeholder himself. See future interests and perpetuities and property summaries. B. All beneficiaries existing and competent 963. The requirement that all beneficiaries must be legally competent sui juris and give otherwise valid consent has been held to mean what it says. Under this meaning, it would not be possible to obtain consent from all beneficiaries when any possible beneficiary, I may be afterborn, or Roman II is a minor. 1. Possibility of vicarious consent 964. The consent by a minor's guardian is probably sufficient, and consent by a guardian ad item for unborn or unascertained persons in such situations is beginning to receive some recognition. Hatch v. Riggs National Bank, 361 F2D 559 DC, Sir. 1966, as has the doctrine of virtual representation in Re Estate of Land J. 383 A2D 1E 130 NJ, 1978. See also Rest, 3D 65 CMT. B. UTC 302-305. But C 6 and 7 Eliz. 2. Ch. 53 1958 English Variation of Trusts Act allowing court to give consent for unborn, unascertained, and minor beneficiaries, if in their best interests. Cal. Prob. Code 15E435E406 considerably loosening restrictions on beneficiaries' rights of modification and termination. Exam tip. If on your exam you are asked whether the beneficiaries can compel modification or termination of a trust, the first thing you must do under all views is determine who are all the possible beneficiaries, whether born, unborn, ascertained, or unascertainable, of all the interests present, future, vested, or contingent. Second, you must decide whether it is possible to obtain consent from all such beneficiaries. Keep in mind that unborn or unascertainable beneficiaries, e.g., a living person's heirs, and minor beneficiaries cannot consent. But also note the possibility of vicarious consent. 3. Material purpose of Settler 965. Under the Claflin Doctrine, but not under English doctrine, the beneficiary's right to terminate or amend a trust by unanimous demand depends on finding that doing so will not undercut a material purpose of the settler. A. Intent differentiated 966. Obviously, by its very nature, a proposed modification or premature termination of the trust involves a departure from a specific intention of the senior as manifested in the terms of the trust. Thus, the Claflin doctrine does not seek to protect every intention or desire of the settlor. It is concerned with the trust's purpose or purposes, and even then only those that are material. 1. Note: it has often been assumed that the question is whether, even to modify, it must be found that termination would not defeat a material purpose, but see rest. 2D 337. But the better view is that, even though termination would violate a material purpose, if the proposed modification would not, the modification is permissible. Rest. 3D 65 CMT. F. UTC 4E 116. B. Inferring purposes 967. Trust instruments rarely include specifications of the settlor's purpose, but, in most cases, only contain the terms that implement some unstated purpose or purposes. Thus, it is generally necessary to speculate about, or to attempt to infer the purposes and whether any such purpose is material. Example: in a trust, for child for life, remainder to grandchild, is the settlor's goal to provide for successive enjoyment by child and grandchild? Or is it to protect child from what the settlor believes to be child's bad judgment, although, traditionally at least, child must be legally competent or the question would not arise? 1. General inference of successive enjoyment 968. Although the authorities are divided and often unclear on the point, the usual view seems to be that courts will generally require some evidence, language, circumstances, etc., from which to infer a material purpose, or else they will infer only a general purpose of providing for successive enjoyment by the beneficiaries, so that all beneficiaries together are free to modify the trust, or to terminate it and divide the assets as they wish. C. Evidence of purposes 969. In determining whether termination or modification would defeat a material purpose of the settlor, courts consider the wording of the trust instrument and the circumstances of its execution. Paro. Evidence of various kinds is also admissible, including the settlor's statements both before and after creation of the trust, as long as they are indicative of the original purpose and state of mind. Most frequently, however, the material purpose that proves to be the obstacle to modification or termination is found in the nature of the trust or in the types of provisions it contains. 1. Support Trust 970. The fact that a trust is for support, e.g., W bequeaths to T to pay such amounts of income or principal or both as T deems appropriate to, or for the benefit of H for his support and care for as long as he lives, sometimes is found to be indicative of a desire to protect a beneficiary from want and from his own imprudence. This purpose would then prevent termination, but it might not prevent a particular proposed modification. This other material purpose may also, but not necessarily, be inferred in the case of a trust that is generally discretionary as to benefits. 2. Trust until stated age 971. The result is somewhat better settled in the case of a trust for a particular beneficiary until a specified age, after which the trustee is to distribute corpus to that beneficiary, or to her estate or other successors if she dies before that age. Here courts infer a purpose to keep the property out of the beneficiary's control until the stated age is reached, and this stands as a barrier to early termination. Example: in trust to apply such amounts as needed for the support of grandchild until age 21, and then to pay all of the net income to grandchild annually until age 30, with the trust then to terminate and the estate to be distributed outright to grandchild. When grandchild reaches the age of 21 and seeks termination, the petition will be denied. 3. Spendthrift Trust 972. Apparently in all cases from Claflin jurisdictions, it is held that if a spendthrift restraint is validly imposed on the interest of any of the beneficiaries, the trust cannot be terminated, even though such provisions are often included routinely by lawyers with no conscious concern having been expressed by the settler client about a beneficiary's imprudence. It is possible that courts are simply focusing on the inalienable nature of the interest, and that termination or modification is viewed as a form of alienation and exchange. But most cases rely on the apparent protective purpose as a material purpose of the settler. Rest. 3D65 CMT. Spendthrift restrictions are not sufficient alone to establish, or to create a presumption of, a material purpose that would prevent termination by the beneficiaries, and CUTC4 LLC spendthrift provision not presumed to constitute a material purpose, but this provision is now bracketed suggesting no uniformity objection if an adopting state omits it. 4. Abandonment or removal of material purpose 973. To what extent may a trust be terminated or modified by beneficiaries because the purpose is abandoned by settler or disregarded by act of trustee, or because its forced continuation becomes pointless or unlawful? A. Position of settler 974. Although the settler, unless also a beneficiary, generally has no right to enforce a trust, her role may or may not be significant in a material purpose case under the clavel in doctrine. But see rest. 3D 652 also allowing court, after settler's death, to waive purpose if outweighed by beneficiaries' concerns. 1. Consent 975. If a living settler consents to the request of all beneficiaries, no material purpose will stand in their way, i.e., the settler may permit the beneficiary's action by relinquishing or waiving the purpose that would otherwise be an obstacle. Scholz v. Central Hanover Bank and Trust Co. 295 NY. 488 1946. 2. Opposition 976. The settler's opposition, however, does not prevent the beneficiaries from terminating or modifying the trust if the court concludes that the change would not defeat an original purpose of the settler. Rest. 3D65 CMT. Nor can her consent cure a lack of unanimous beneficiary consent. Of course, the settler's views or testimony might well have some persuasive influence on a court in its efforts to ascertain the trust's purposes. 3. Settler is sole beneficiary 977. Where the senior is herself the sole beneficiary of a trust, or becomes so, she may amend or terminate the trust, even without having reserved the power to do so, because she holds all beneficial interests, and regardless of any material purpose thereby defeated, for she can release it. Bixby v. California Trust Co. 33 Cal. 2D 495 1949. Rest. 3D 652. B. Trustee's disregard of trust and possible liability for breach of duty 978. If all beneficiaries request a modification or termination, and despite a material purpose, the trustee acquiesces and distributes the trust estate to them, it has been held that the beneficiaries cannot later object or assert a claim for any loss caused by the premature distribution, i.e., they are estopped. Washington Loan and Trust Co. v. Colby, 108 F2D 743 DC. Sir. 1939, but the few authorities on point are unclear with respect to spendthrift trusts. Given the protective purpose of such a trust, the beneficiaries may not be subject to estoppels far as the trust assets are concerned. The setter might try to raise the objection that the distribution defeated her material purpose in creating the trust. Unless the settler was a non-consenting beneficiary with, e.g., a power to revoke or other interest, this would fail, not only because of lack of injury, but because absent a contrary statute she has no standing to enforce the trust, even though she created it. C. Purpose frustrated or impermissible. 1. Spendthrift protection, not needed 979. Where the beneficiary whose interest the spendthrift provision was to protect has died or no longer holds his interest, the trust may be terminated, unless to do so would violate another material purpose. 2. Perpetuities period expired trust, no longer indestructible 980. By operation of law, The restraint upon the freedom of the beneficiaries ends, as does the law's deference to the settler's purpose. Once the applicable perpetuities period has expired, lives in being plus 21 years, under the common law rule against perpetuities. Although as long as all interests are vested, a trust may endure beyond the period of the rule. The trust can no longer be indestructible. D. Power of courts to modify or terminate. 1. Judicial power to deviate from or modify administrative provisions. A. Conditions for equitable deviation from Trust Terms 981. By the traditional view, a court of equity may authorize or direct the trustee to deviate from, or even modify, the administrative terms of a trust, and thus to perform acts otherwise forbidden whenever, due to changed circumstances unforeseen by the setter, compliance with the original terms of the trust would defeat or substantially impair one or more of the trust purposes. Rest. 2D 167 Many statutes, e.g., VTC 412, a few cases, and the third restatement rest. 3D 66 take a modestly, but significantly more liberal view. 1. Unforeseen circumstances required 982. The rule is intended to protect, not to disregard, the actual or probable intentions of the settler. Therefore, circumstances must have changed since the trust was established, and the changes must have been ones not contemplated by the setter. In Re Trusteeship of Mayo, 105 NW2D 900 Min. 1960 under the VTC and Third Restatement View Supra, it is sufficient that the circumstances involved were not anticipated, e.g., had already occurred, but were not known by the settler. 2. Only where necessity exists 983. Also, under the traditional view, deviation is allowed only if adherence to the terms of the trust would jeopardize the settler's original purpose. A mere showing that modification would be in the best interests of the beneficiaries, or that it would improve or facilitate administration, is not enough. See, e.g., Stanton v. Wells Fargo Bank and Union Trust Co., 150 Cal. App. 2D 763 1957. Rest. 2D 167 CMT. B. But see in Re Trusteeship of Mayo, Supra, given that the circumstances were unanticipated, and that the settler's likely intentions are to be served. The liberalized view Supra is that deviation is justified to further the purposes of the trust. Rest. 3D 661 BTC 412A. B. Effect of Express Trust Provision 984. The mere fact that the settler has, in the trust instrument, directed or forbidden the trustee to perform the particular act which the trustee now seeks to perform, or a beneficiary now seeks to have the trustee directed or authorized to do, does not preclude deviation. The question is whether the settler would have so intended had she known of the circumstances. 1. Explicit prohibition or direction. A. Sale forbidden 985. Even under the stricter traditional view, if the settler forbade the trustee to sell or encumber trust property, the trustee may be authorized by the court to do so if the circumstances have changed in a way not foreseen by the settler, and the sale or encumbrance is now necessary to preserve the trust estate or to provide for the beneficiaries. Trustees of Alexander Lynn Hospital Association v. Richmond, 135 A2D 221 NJ, 1957. Example. Even though the trust terms direct the trustee to retain the shares the settler owned in his longtime employer, the court may allow or require the trustee to sell those shares, if necessary, to prevent such a serious loss of trust income or value that a trust purpose would be threatened. B. Termination of trust activity 986. Even a termination of the trust's principal activity may be authorized if the court finds that continuance of the activity would jeopardize the settler's original purpose. Rest. 2D 336. Example. Where a trust was created with the direction to retain and carry on my farm, the farm operation may be terminated and the property sold if it appears that, due to unforeseen changes affecting the farm, continued operation would inevitably result in loss of the farm. 2. Provision forbidding any modification 987. If the settlor expressly provided against any modification of the trust, courts might be particularly reluctant to authorize deviation from the original terms. Nevertheless, if a court were convinced that the settlor had not considered the particular unforeseen circumstances that have occurred, deviation would probably be ordered. N. Re-estate of Pulitzer, 139 Misk. 575-1931, aft. 237 AD. 808-1932 John H. Langbein. The Uniform Prudent Investor Act and the Future of Trust Investing. 81 Iowa L. Rev. 641-1996. Example: Joseph Pulitzer instructed his trustee to continue to publish the New York World newspaper and prohibited sale of the stock of the publishing company. Losses incurred in publishing the World jeopardized not only the profits, but also the other assets of the trust. The court directed the trustee to sell the publishing company stock. In Re-estate of Pulitzer, Supra. C. Liability of Trustee 988. Where the trustee knows or should know of circumstances justifying a deviation from the original terms of the trust, he may be liable if he carries out those original terms. A trustee's fiduciary duties include a duty that obligates him to apply to an appropriate court for instructions under such conditions, with liability for a loss if he fails to do so. Rest. 3D 662. 1. Exception Emergency 989. A trustee may be exempt from liability if he deviates from the original trust terms without first obtaining court permission, if an emergency exists requiring immediate action, and perhaps even if he reasonably believes such an emergency exists. Rest. 3D 66 CMT. E. 2. Power regarding distributive provisions 990. Equitable deviation has generally been recognized only with respect to the administrative provisions of the trust, as distinguished from the distributive provisions. More precisely, this majority common law rule applies to alteration of the trust terms in a way that results in taking from one beneficiary and giving to another, i.e., the court cannot add or remove a beneficiary or affect the amounts or shares the beneficiaries are to receive. Staley v. Ligon, 210 A2D 384 MD, 1965. Example: a trust is created to pay income to brother for life, and on his death to distribute the principal to child, and no provision allows the invasion of principal for brother's benefit. Under the usual common law view, the court will not permit the trustee to distribute any principal for brother's benefit, because this would affect child's share, no matter how serious brother's need or how likely it is that the settlor would have wished an invasion. A. Minority View 991. A few cases, and an increasing number of statutes allow deviation, even of this type, involving distributive provisions. See Cal. Prob. Code 15E49. Fla. Stat. 736-41115. Petition of Walcott. 56 A2D 641 NH. 1948. This is also the third restatement and UTC view. Rest. 3D 66. UTC 412. B. Exception Acceleration of Indefeasibly Vested Rights 992. Even under the majority common law view, if an invasion of principal or anticipation of payments would not affect the interests of any other beneficiary, in the very rare situation in which there would be no change in the ultimate, even contingent rights of others to receive distributions, a court may permit a change in the time or conditions of payment upon a showing of changed circumstances. Rest. 2D 168. Example: a trust was to accumulate income during my son's minority and distribute principal and accumulated income to him on his coming of age. If it turns out that the son who appeared well provided for when the trust was established is in need during his minority, because he is sole beneficiary of the trust or of an independent share of the trust estate, the court could modify the terms of the trust or authorize deviation to permit present distributions. C. Construction to allow invasion 993. In several cases decided by courts that purport to adhere to the majority common law rule in this matter, the courts have been able to find by construction, rather than grant by deviation, a power to invade implied from the language and terms of the trust instruments, which contained no such express power in favor of the needy income beneficiary. Longworth v. Riggs, 14 NE, 840 ill. 1887. D. Distinguished Cypres Doctrine and Charities 994. On the judicial power to modify not only administrative provisions by equitable deviation, but also the purposes of charitable trusts under the Cypres power in appropriate circumstances. See Supra 583-598. Exam tip. Recall that the Cypres doctrine allows a court to deviate from the trust's original purpose and modify it to fit current circumstances. To invoke Cypres, the court must find I that the designated purpose has been fulfilled, or has become illegal, impossible, or impracticable to carry out, and Roman 2 under the traditional view that the settlor had a general charitable intent. See Supra 583-598. E. Termination of trusts by operation of law. 1. Expiration of trust term 995. If the trust instrument specifies the duration of the trust terminates by its own provisions upon expiration of the specified period. Rest. 3D61. The trust term may be for a number of years, but more often it is until the happening of a certain event, e.g., until the death of my wife. 2. Trust purpose fulfilled or prevented 996. Where the purposes for which the trust was created have been completely fulfilled, e.g., to provide such funds as are necessary to pay for my son's college education. The trust terminates by operation of law, even prior to the expiration date set in the trust instrument if I. The trust purposes have been accomplished, e.g., the settlor's son has completed college, or Roman 2. The trust purpose has become illegal or virtually impossible, e.g., the settlor's son has become mentally incompetent, or, possibly, has reached an advanced age and shows no desire to go to college. Rest. 3D61. Compare Cypres and charitable trusts. Supra 583-598. 3. Merger of estates 997. A trust terminates by operation of law where there has been a merger of the legal and beneficial interests, e.g., beneficiaries assign their entire beneficial interest to the trustee. Rest. 3D69. 4. Destruction or consumption of trust estate 998. Finally, when the trust estate ceases to exist, the trust terminates by operation of law. Thus, where all trust assets have been consumed or lost, or otherwise cease to exist, the trust likewise ceases to exist. Rest. 3D30. A. Small estates 999. Growing case law and statutory authority indicates that a trust can be terminated by a court when the trust estate becomes so small as to render its continued operation impracticable and its purposes impaired. Cal. Prob. Code 15E 408. Rest. 3D66 CMT. D. UTC 412. Termination of trust by operation of law. A trust terminates by operation of law when the trust's specified period expires, the trust purposes are accomplished or become illegal or impossible, but consider Cypres if charitable trust. All legal and beneficial interest merge. All or under growing authority most of trust assets are consumed, lost, or destroyed.